All rise. The Lawyer of the Apes is now in session. How's it going, everybody? Welcome to episode 6 of Lawyer of the Apes. Today, we're going to be discussing the Robinhood Class Action Complaint, specifically going over today count 1, which is the negligence count. The plaintiffs in the class action are alleging that Robinhood was negligent in the way they handled the situation that took place. And they're saying that the harm that was caused to them was essentially because of the taking away of the buy button, they lost money. They suffered damages. Now, the thing is, which is odd about this for me, when I look at this initial count, is negligence is not usually something related to monetary loss. Usually, negligence is something you see in the world of torts. Now, torts involve injuries to the person, to a person's physical self. For example, medical malpractice. If a doctor, performs surgery on you and they leave a scalpel in your body when they sew you up, or if they operate on your left foot, but they were supposed to operate on your right foot, that's negligence. That is something that results in a duty of care that was owed to you by a professional person, and that professional person messes up, leading to an injury to you as an individual. You rarely see an allegation of negligence in something like this. This is more along the lines of a breach of contract action, where there's an agreement between the parties. I say I'm going to do something. I sign up for your service in this case, and I say I'm going to purchase stocks from you. And you were basically saying you will make sure that I'm able to purchase my stocks. Now, that is technically a breach of contract agreement. However, you probably would say to yourself, and just like I said to myself, why wasn't there a breach of contract action filed in this case? Well, the answer is pretty simple, and it's actually pretty crazy. There was a case that was already filed that's sort of, in line with what happened here. It's not completely on all fours with the case, but it is analogous to the case. And it's probably the reason why the plaintiffs didn't go for the breach of contract action. First and foremost, before I get into that case, the general idea and the most basic idea of it is because, remember, when you enter into a contract, there's a crap ton of fine print. And obviously, not everyone reads the contract. Failing to not fully read the contract, there's no obligation on anybody for that other than the person signing the contract. So if you miss something, it's sort of too bad, so sad. You have to really be careful and pay attention to what you're signing up for, no matter what it is. And that's just a general rule of life. But also, it shows you how dangerous it is when you're entering into an agreement to buy and sell in the market. You really want to make sure that whoever you're signing up with, you have some protections in place. And Robinhood specifically states in their terms of service and their user agreement that they do not guarantee uninterrupted service. So because they don't guarantee uninterrupted service, and that says it in their contract, winning a breach of contract action would be very difficult. Now, again, that was already tested in another case, and I'm going to point you guys in that direction now and go over it. The name of that case was Whitesides versus E-Trade Securities. That case was filed just very recently, back in 2021, and the decision came out in March. And what happened was this: the plaintiffs in that case were customers of E-Trade, and they were all holding on to oil future contracts, and the price fell below zero. And then at that point, the plaintiffs all alleged that they immediately attempted to sell off their contracts when that happened, but they were unable to do so because of a system-wide failure affecting E-Trade's trading platform. Because of that, the plaintiffs all asserted that they suffered losses, and due to their relationship, they said that they would want to pursue an action against E-Trade. And basically, they used the customer service agreement, similar to what they're doing in this case with Robinhood. Now, the allegations that were set forth initially were breach of contract, breach of duty of good faith and fair dealing, negligence, gross negligence, etc. So very similar to this case. But again, the breach of contract action was immediately removed by the plaintiffs because of the contract terms stating that they did not guarantee a uninterrupted service. Now, the negligence part was also addressed in the E-Trade case, and the news on that aspect of it was also not very good. E-Trade in that case filed a motion to dismiss, and the parties were allowed to amend their complaint. They amended their complaints, but even after they amended their complaints and updated it, the court still ruled in favor of the defendant and dismissed the complaint. They said in that ruling that the negligence exculpatory clause contained in the customer agreement governed the decision. The court gave credence to E-Trade's argument that the clause absolved it from liability from ordinary negligence. So basically, they said that you cannot make an allegation of negligence because the terms of the contract specifically state that that the individual company cannot be held liable for negligence. So now let's take a look at the complaint against Robinhood. Okay, so we're seeing here again a similar count one, negligence, which we already know that the courts in other cases have rejected due to the user agreements. But let's just take a look at it. Robinhood has a duty to exercise reasonable care, skill, and ability in conducting and facilitating financial services and transactions on its platform. So basically here, they're saying, look, Robinhood had a duty, right? The duty was to make sure that they were going to operate this business with reasonable care, skill, and ability. They should have known that there was a possibility that they could have been margin called for the and stretched too thin, and that this owing of potentially upwards of over $3 billion could have happened in a volatile market, and they should have been aware of that. And because they weren't aware of that, they have committed negligence. Robinhood owes a duty of care to investors to act in accordance with a standard of care by other broker-dealer professionals. Robinhood assumed a duty to ensure that its trading platform is sufficiently equipped to reliably deliver such services under reasonably foreseeable increase in customer demands and resulting market conditions. Duty to exercise reasonable care in safeguarding plaintiffs and members of the class's investments by providing a platform to execute trades that is fair, promptly provides execution of its customers' trade orders in a lawful manner. Now here, this is an interesting part, because it says here, execution of its customers' trade orders in a lawful manner. Now remember, negligence is probably not. This cause of action, honestly, seems very weak to me as a general negligence term. Based upon the E-Trade holding, it's going to be very difficult to overcome the hurdle. However, the difference, I think, in this case is that there is an exception carved out for fraud. If they can establish that fraud was committed in perpetrating this, then there may be an ability to show negligence. In the E-Trade case, there was no allegation of fraud against them. They never said that E-Trade committed fraud. E-Trade was a true glitch, according to what they asserted in their complaint. But in this case, we know that we're not asserting a glitch. They are asserting a very clear-cut violation of individuals' rights to purchase stock by Robinhood through a collusive act with other individuals. So if they combine the negligence aspect with an element of fraud, then they may be able to overcome the negligence decision in the E-Trade case. However, in the complaint, they did not really do that. I read it a few times, and they do make generalized statements, obviously, of a collusional act and a conspiracy with the Citadel, but they really don't tie it into the negligence. So they may be submit. My guess is that they're going to submit probably another amended complaint on this to make it a little bit more detailed. But I think that's really where they have to go. Duty to exercise reasonable care in safeguarding plaintiffs and the members of the class's investments by providing a platform to execute trades that is fair and promptly provides execution of its customers' trade orders in a lawful manner. As I said before, lawful manner seems to be the key word there. Robinhood Securities had a duty to exercise reasonable care in carrying and providing clearing services for its customer accounts, ensuring compliance with obligations to meet capital requirements to cover foreseeable market risk, and ensuring that it had sufficient collateral posted or available to satisfy the industry clearing functions so as to not impede plaintiffs and the class's ability to purchase shares of suspended stocks. Remember, when you're looking at a negligence case, right, you're looking at it from the perspective of, did the individual act reasonable under the circumstances when compared to other individuals in the same community? So for example, if I am a construction worker and I'm working on a job site and I have a hammer in my hand and I am banging the hammer and I hit the person next to me. Well, the question would be, did I act in any way different than another construction worker would? So the comparison would be another construction worker under the circumstances. So if this construction worker was, just ordinary on the job, using his hammer and accidentally struck someone's thumb, it would be difficult for them to show that he acted outside of his function as a reasonably acting construction worker. Now, if the construction worker showed up to work drunk, then that is not how a reasonable construction worker would act, and therefore there would be an easier case to establish in negligence. So here we'll have a similar situation. They'll have to question whether or not a similar broker in a similar situation would have acted in the same way as Robinhood did, based upon what they were confronted with at the time. And when you look at it, based upon the crazy thing is, we actually do have a multitude of other brokers that did act differently at the same time. So on that front, I think their case is strong. They can show that other brokers acted more reasonable under the circumstances. Now, the other brokers may not have had the same margin requirements or the same issues when it came to the ability to cover their capital issues. But even if that's not the case, it's still likely that they owed some money. And then the question would also be, should it have gotten that far? Should Robinhood were they operating too big for their britches at the time? And then if that was the case, then they could also be held liable, because that is negligent. If you're operating in a way above your means and you're not letting your customers know that, well, if my intention is to be able to buy as much stock as I want, no matter what the market conditions, because I'm assuming you have the collateral to back it up, that also could be considered negligence. By failing to take reasonable steps to make sure that its platform is available in times of market volatility, failing to maintain adequate capital to meet the increasing risk associated with trading volume, Robinhood intentionally fueled, admittedly failing to have adequate capital to pay its clearinghouse mandated deposit requirements. In other words, after bringing itself and its customers to the brink, Robinhood intentionally disrupted the market its business was ill-equipped and unable to handle by severing one of the two requisite legs for a fully functioning market, when it knew or ought to have known that its customers would suffer immediate drops in the value of their portfolios and the market of the suspended stocks would be significantly impaired. Robinhood had a duty to maintain adequate capital and collateral during volatile markets, and the volatility was either known to Robinhood or foreseeable. Remember, they didn't have to know it was going to be happening. It had to be foreseeable to them. That's the question. It's not that Robinhood knew, it's that they knew or should have known that it was possible. Robinhood's failure to maintain capital levels needed to meet anticipated capital deposit demands, failing to adequately mitigate risk and restricting trading in the suspended stocks under the circumstances alleged herein, violated SEC, FINRA, and other regulatory rules, which violations provide evidence of breach of duty of care owed to its customers in extreme departure from the ordinary standard of conduct, and conduct so reckless or wanting in care that it constitutes a conscious disregard or indifference to the rights of the plaintiff and the class. So again, guys, so that's the negligence part. We'll get into the gross negligence part tomorrow, or actually not tomorrow. Tomorrow is October 5th. So we're going to be getting the reply papers on the antitrust action. So we're going to go through that. But here, look, the negligence argument in this case is very novel. This is not something you see all the time. It's very fascinating from a legal perspective, because this is not something you see every day. Negligence is usually something that involves harm to an individual's person, to your body. So it's really odd to see this, and it's very fascinating. And it'll be interesting to see what the court does, because this is definitely a newer area of the law. The E-Trade case, if I was a lawyer in this case, I would distinguish it. I would say that in the E-Trade case, the E-Trade was a glitch, and that was, unavoidable. They could not have foreseen that glitch happening, arguably, and because of that, that's the reason why they dismissed in that case. In this case, having enough collateral in the bank is, everyone should be communicating with each other in regards to other brokerages, just like we had seen in the other complaint and in the motions, that this is a very tight-knit community. So everybody's, usually in the know about what they need to maintain the abilities to keep trades open and keep their brokerages afloat. So the distinction could be pretty significant, especially if they can establish some type of fraud or conspiracy aspect to the case, because then that would totally take it outside of and make it an exception to the rule, and then they could definitely prevail on that aspect of it if they're able to succeed in coming to that conclusion. But for now, that's all I have on the negligence aspect. It's very interesting. I'll definitely be curious to see what their motion to dismiss says. I'm sure they'll say a lot about it, like I said, in that regard, and definitely cite to the E-Trade case. Also down here, the other part that was interesting to me was this last paragraph, where the plaintiffs alleged that there was a violation of SEC rules. Again, they will raise that issue again, that if this is an SEC issue, then this is not the proper forum. If it's an SEC issue, then this should be taken up by the SEC, and they should be taking care of this, and this should be handled not in the courts, but before the SEC. And that's, again, interesting that this is here. Now, remember, in the other case, in the antitrust case, there was an exception to the rule under the Dodd-Frank Act, which would probably protect the people in that case on the antitrust. Now, when it comes to class actions and SEC, there's a different set of rules, which I'll get into probably when they put more in detail when they file their motion to dismiss. But I would bet you that they're going to include that argument in their motion to dismiss as well. All right, so listen up, everybody. That's the video for today. I do want to just briefly talk about the whole Bank of America thing. The Bank of America issue came up over the last 24 hours. I just want to touch base on it really, really quick. What was my Twitter feed? And I had posted on it, but just in case anybody didn't see my post, this was floating around. Where is it? Oh, here it is. So this was floating around on Twitter over the last 24 hours among the hype surrounding the Bank of America possibly going bankrupt. This is a image screenshot from the United States District Court of Utah, which says motion for relief from stay filed by Bank of America NA. Now, this is not a filing of bankruptcy or bankruptcy relief being sought by Bank of America. This is basically a situation where Bank of America held a loan, whether it was a mortgage or a car loan or whatever it may be, against an individual. And what happened was that individual filed for bankruptcy. Now, when someone files for bankruptcy, they have, they enter into an agreement where they are going to make certain payments over a certain period of time. And under the terms of that agreement, the bankruptcy, there's a stay put in place on creditors from being able to take money that is owed to them. So basically, this is a situation where the individuals must have not been keeping up on what they were supposed to be doing in their bankruptcy proceeding. And Bank of America filed an action basically saying, listen, they haven't been doing what they're supposed to be doing, so therefore we now want to assert our collection action against them. And that's all this is. This had nothing to do with Bank of America filing for bankruptcy. This goes back to one of my first videos about the importance of how we present our cases and credibility on the internet. You definitely want to make sure before you start posting things that they actually stand for the proposition that you're trying to assert, because if you don't, then you sort of like lose credibility, and these guys will use everything against us. So it's really important to try to make sure that whatever we do post is based upon facts rather than speculation and conjecture. So with that said, guys, I'm looking forward to tomorrow's video. Tomorrow we'll have episode 7, and it will be discussing the reply papers in the antitrust action, which should be very, very interesting. I'm looking forward to see what the defendants' counter arguments were in that. So until then, the lawyer of a Jake The Lawyer of the Apes is adjourned.